Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
It's 2 in the morning. You're flipping through channels half asleep and then, it happens. A man in a stiff, slightly too shiny suit appears. He's standing in front of a bookshelf filled with law books nobody has ever opened. He points directly at you through the screen, and with the gravity of a Shakespearean actor he asks, "Have you been injured in an auto accident? Has a slip and fall changed your life?" We've all seen him. The daytime TV lawyer. The late-night personal injury guru. We laugh, we cringe, we quote the cheesy taglines. One call, that's all. In a wreck? Get a check. It feels like a parody, a low-budget relic from a bygone era. But what if I told you that this cringeworthy commercial is one of the most sophisticated, calculated, and profitable marketing tools in American history? What if I told you that behind that shaky camera and bad tie is a $1.4 billion a year war, fought for your attention on the battleground of daytime television? That's not an exaggeration. American law firms spend over $1 billion every single year on television ads alone. That's more than the entire motion picture industry spends on TV advertising. It's an ocean of commercials for car crashes, medical malpractice, and defective products, all promising you a big payday. This raises a fundamental question. Why? Why are these ads so relentlessly common on American TV, and almost nowhere else in the world? Why do they all feel so similar, so cheap? And how on earth does a single phone call from a single car accident victim justify this billion-dollar gold rush? Over the next few minutes, we are going to pull back the curtain on the secret world of legal advertising. This is not just about bad commercials. This is a story about a landmark Supreme Court decision that changed America forever. A multi-billion-dollar marketing war fought in 30-second battles, and the powerful psychological triggers these lawyers use to get you to pick up the phone. By the end of this journey, you won't just understand why you see these ads. You'll understand the entire American legal system in a way you never have before. You'll be able to spot their tactics, understand the mind-boggling economics behind a single client, and see how this advertising frenzy has fundamentally reshaped the very concept of justice in the United States. And it all starts with a time that feels like a foreign country, an America where a lawyer advertising on TV was not just unthinkable, it was illegal. To understand our world of screaming TV lawyers, you have to imagine its complete opposite. Picture America before 1977. For nearly a century, the legal profession was governed by a strict code of ethics set by the American Bar Association, or the ABA. And rule number 1, you do not talk about law club. Lawyers were forbidden from advertising. Not just on TV, they couldn't advertise anywhere. No radio spots, no newspaper ads, no billboards, not even a flashy sign on their office door. The thinking was that law was a dignified, noble profession, not a common trade. Lawyers were supposed to be stoic, respected members of the community, like doctors or clergymen. They didn't hustle for business. They acquired clients through reputation, word of mouth, and quiet handshakes at the country club. This created a very specific kind of legal landscape. The big, established law firms in downtown skyscrapers thrived. They represented corporations, wealthy families, and powerful institutions. Their business came from pre-existing networks of influence. But what about the average person? What if you needed a simple divorce, needed to adopt a child, or just wanted to write a will? You were flying blind. You couldn't compare prices. You couldn't look up a lawyer's specialty. You basically had to ask a friend or pick a name at random from the yellow pages, which by the way was just a name and a phone number, no claims, no promises. This system kept legal services mysterious and, more importantly, expensive. The lack of price competition meant that even simple legal tasks could cost a fortune, putting them out of reach for a huge chunk of the American population. The hallowed profession was, in reality, an exclusive club that served the wealthy and left everyone else to fend for themselves. And this is where our story truly begins. Not in a fancy boardroom in New York, but in a dusty, sun-baked office in Phoenix, Arizona, with 2 young lawyers who were about to set the entire legal world on fire. Their names were John Bates and Van Osteen. These guys were not your typical corporate lawyers. They graduated from law school in the early 70s, filled with the era's idealism. They saw a legal system that was failing ordinary people. They saw their friends and neighbors getting taken advantage of, or simply going without any legal help at all because they couldn't afford the colossal fees charged by the downtown firms. So they came up with a radical idea. They decided to open a legal clinic. Think of it like a primary care doctor's office but for law. Their business model was simple. High volume, low overhead, and standardized services for routine legal problems. They wanted to be the H&R Block of law. They would handle things like uncontested divorces, adoptions, personal bankruptcies, and name changes for a flat, affordable fee. They weren't chasing multi-million-dollar corporate lawsuits. They were trying to help a secretary get a divorce without going broke. It was a brilliant model that could serve a massive untapped market. But it had one fatal flaw. How would anyone know they existed? How could they reach the people who needed them most? They were stuck. The ABA's strict no advertising rules meant they couldn't even put a flyer in the local supermarket. Their revolutionary idea was doomed to fail in silence. They were trying to sell a life-saving product, but were forbidden from telling anyone it was on the shelf. After struggling for a few years, watching their dream of accessible justice wither on the vine, they reached a breaking point. They decided they had to do something. They had to fight back. So, on February 22, 1976, they committed an act of professional heresy. They took out a small, incredibly modest advertisement in the Arizona Republic newspaper. It wasn't a flashy full-page ad. It was a simple text-only block that looked more like a classified listing. It was humble, it was dry, and it was illegal. The ad was titled, "Do you need a lawyer?" And below it, it listed their services and their prices in plain black and white. Divorce or legal separation, $175 plus $20 court filing fee. Adoption, $225 plus publication costs. Today this seems completely normal. But in 1976, this was a bomb going off in the center of the American legal establishment. No one had ever publicly listed prices for legal services like this. They had broken the sacred code. The reaction was swift and brutal. The State Bar of Arizona immediately launched a disciplinary proceeding against them. They were accused of unprofessional conduct, of cheapening the profession, of violating the sacred canons of legal ethics. They faced the ultimate penalty for a lawyer: disbarment. Losing their licenses, their careers, everything they had worked for. John Bates and Van Osteen, two idealistic lawyers who just wanted to help regular people with their legal problems, were now public enemy number one, locked in a battle with the entire legal system. They had two choices: apologize, pull the ad, and save their careers, or double down and take their fight to the highest court in the land. A battle that would either destroy them completely or change the face of American law and American television forever. They chose to fight. For John Bates and Van Osteen, apologizing would have been easy. It would have saved their careers, smoothed things over with the legal establishment, and let them go back to their quiet lives. But the principle of the thing, it gnawed at them. They believed they had a right to communicate with the public. More than that, they believed the public had a right to hear from them. So they doubled down. They refused to pull the ad. They refused to be silenced. And in doing so, they officially declared war on the entire legal profession of Arizona, and by extension, the United States. The State Bar didn't hesitate. They were the gatekeepers, the guardians of the profession's ancient traditions, and these two upstarts had spat on the front door. A formal complaint was issued. A hearing was held. The verdict was swift and brutal. John Bates and Van Osteen were found guilty of unprofessional conduct. Their punishment was suspension from the practice of law. It wasn't just a slap on the wrist, it was a career death sentence, designed to make an example of them. To any other young lawyer, this would have been the end. The fight was over. The establishment had won. But for Bates and Osteen, this was just the beginning. They appealed the decision to the Arizona Supreme Court, and they lost. The state's highest court sided with the bar, upholding the suspension and reaffirming the sacred, centuries-old ban on lawyer advertising. At this point, they were broke, ostracized by their peers, and legally defeated in their own state. They had one last, desperate, Hail Mary option: to appeal to the Supreme Court of the United States. It was an almost laughable long shot. The Supreme Court receives over 7,000 petitions a year and agrees to hear only about 100 to 150 of them. The odds were astronomically against them, But their case wasn't just about a little newspaper ad anymore. It was about a fundamental clash of two American ideals: the freedom of speech versus the regulation of a profession. To understand the battle that was about to unfold, you have to understand the two armies. On one side, you had the entire American legal establishment, represented by the State Bar of Arizona. Their argument was rooted in a single powerful idea: professionalism. For centuries, law was considered not a business, but a noble calling, a public service. Lawyers were officers of the court, seekers of justice, not merchants hawking their wares in a noisy marketplace. They argued that advertising would debase the profession. It would turn the solemn practice of law into a circus of slick slogans and flashy promises. It would encourage lawyers to stir up frivolous lawsuits just to generate business. They warned of a race to the bottom, where lawyers would compete on price instead of skill, leading to shoddy work that would ultimately harm the very public they were sworn to protect. In their view, the ban on advertising wasn't about protecting lawyers' wallets. It was about protecting the dignity and integrity of the justice system itself. It was about maintaining a sacred trust between the public and the legal profession. On the other side stood John Bates and Van Osteen, two young, unknown lawyers with a radical idea. Their argument was built on two pillars: the First Amendment's guarantee of free speech, and something even more fundamental: the public's right to know. They argued that the ban on advertising was, in reality, a form of censorship that kept consumers in the dark. How could an ordinary person make an informed decision about hiring a lawyer if they had no information? How could they know who specialized in divorces or wills or personal injury? How could they compare prices to find legal services they could actually afford? Bates and Osteen argued that the ban didn't protect the public. It protected the established old boy network of powerful law firms. By keeping prices and services a secret, the ban prevented competition. It allowed big, expensive firms to maintain their monopoly, charging high fees that were out of reach for most middle-class and low-income Americans. For them, this wasn't about demeaning a profession, it was about democratizing it. It was about giving the average person, the factory worker, the schoolteacher, the small business owner, access to basic information about the legal system that was supposed to serve them. Their newspaper ad wasn't a cheap gimmick. It was a public service announcement. It was a crack of light in a system that had been deliberately kept dark and mysterious for far too long. So there it was, a showdown between tradition and progress, between the perceived dignity of a profession and the practical needs of the people. And against all odds, the Supreme Court of the United States agreed to hear the case. In 1977, the fate of every lawyer, and every future television commercial, rested on the arguments that would be made in the case of Bates v. State Bar of Arizona. The 9 justices listened intently as the two sides laid out their visions of the world. The lawyer for the State Bar painted a grim picture of a future filled with ambulance chasers and misleading claims, a world where the pursuit of justice was replaced by the pursuit of profit. Then the lawyer for Bates and Osteen stood up and painted a different picture, a world where a single mother could find an affordable lawyer for a child custody case, where an elderly couple could easily find someone to write their will, where information flowed freely, empowering citizens and making justice more accessible for everyone. On June 27, 1977, the Supreme Court delivered its landmark decision, and in a stunning 5-4 ruling, they sided with the two young rebels from Arizona. The court declared that the State Bar's ban on advertising was a violation of the First Amendment. Justice Harry Blackmun, writing for the majority, dismantled the establishment's arguments one by one. He wrote that the idea that lawyers were somehow above trade was an anachronism. He dismissed the fear that the public would be easily misled, stating, "We suspect that the average citizen is not in need of such solicitous protection." But the most powerful part of the decision went to the very heart of Bates and Osteen's argument. The court recognized that for the legal system to work, people needed to be able to access it. And they couldn't access it if they didn't know it existed or couldn't afford it. The ruling stated, the consumer's concern for the free flow of commercial speech may be as keen, if not keener by far, than his interest in the day's most urgent political debate. In other words, knowing you can get a divorce for $200 might be more important to your life than knowing about a foreign policy dispute. The Supreme Court effectively said that legal services were not some mystical right, but a service just like any other. And the people who needed that service had a right to know about it. The decision was an earthquake. It sent shockwaves through the American legal establishment. The old rules were shattered. The dam had broken. For the first time in American history, It was officially legal for a lawyer to advertise their services to the public. The victory for Bates and Osteen was absolute. They had taken on the entire system and won. They had changed the law. But what they couldn't possibly have imagined was how profoundly they were about to change the culture. The court's decision opened a door, but what came rushing through was a force of nature that no one, not the justices, not the state bar, and certainly not Bates and Osteen, could have ever predicted. The era of the quiet, dignified newspaper ad was about to end, and the era of the loud, unforgettable, and utterly bizarre television lawyer was about to begin. The Supreme Court's gavel had fallen, and in the silence that followed, a strange new world was dawning. But the change wasn't instantaneous. It wasn't like the day after the ruling. Every lawyer in America suddenly had a film crew in their office. Far from it. For most of the legal profession, the idea of advertising was still deeply distasteful. It was something you associated with used car salesmen and miracle vegetable choppers, not learned members of the bar. The old guard, the partners in mahogany-paneled offices who secured clients through handshakes at the country club, were absolutely appalled. They saw it as the end of decorum, the cheapening of a noble profession. So the first forays into this new territory were timid. They were cautious. A lawyer might take out a slightly larger ad in the yellow pages. Maybe a newspaper ad that, instead of just listing their name and address, dared to mention they specialized in matrimonial law. It was revolutionary, but it was still quiet. The first television ads were much the same. A man, almost always a man in a stiff suit, sitting in front of a wall of leather-bound books he'd probably never opened. He'd look directly into the camera with the rigid discomfort of someone at their first school picture and say something like, "I'm John Smith of Smith & Associates. If you've been injured in an automobile accident, you may be entitled to compensation. Please, call our offices for a consultation." And that was it. It was dry. It was boring. It was basically a business card that talked. But a few lawyers, the ones on the fringes, the ones who didn't have a country club membership, saw something else. They saw an opportunity. They understood that television wasn't a newspaper. You don't just present information on TV. You tell a story. You create an emotion. You build a character. Two of the most important pioneers in this new field were Leonard Jacoby and Stephen Myers. They weren't your traditional lawyers. They opened a legal clinic in a shopping mall in Los Angeles, aiming to serve middle-class and working-class people who were terrified of the cost and complexity of hiring a lawyer. Their motto was revolutionary. Justice shouldn't be a luxury. When the Bates decision came down, they went all in. They understood the assignment. Their first commercials weren't set in a stuffy law library. They featured regular people, actors playing clients talking about their problems. A divorce, a landlord dispute, a minor car accident. And then Jacoby and Myers would appear, not as intimidating legal scholars, but as friendly, approachable problem solvers. They spoke in plain English, not legalese. They offered set prices for routine services, demystifying the process. For millions of Americans, this was the first time a lawyer had ever seemed human, accessible. The ads were a phenomenon. Their business exploded. They proved that there was a massive untapped market of people who needed legal help, but were too intimidated or too worried about the cost to ever pick up the phone. And they revealed the fundamental economic engine that would drive the lawyer commercial boom for the next 40 years. Television advertising was cheap, and legal settlements were not. Think about the TV schedule in the late 70s and early 80s. Who was watching television at 11 in the morning on a Tuesday? Or at 2 in the afternoon? People at home. Retirees. The unemployed. Stay-at-home parents. And, crucially, people who were laid up on the couch recovering from an injury. The exact people a personal injury lawyer wants to reach. Those daytime and late-night ad slots were dirt cheap. A local station might sell a 30-second spot for a few $100s. Now, consider the business model of a personal injury lawyer. It's built on the contingency fee. The lawyer takes a case with no upfront cost to the client. If they lose, they get nothing. But if they win, they take a percentage of the settlement, usually around 30 to 40%. So, a lawyer could spend $50,000 on a massive television ad campaign. That campaign might bring in 100 phone calls. Of those 100 calls, maybe 20 turn into actual cases. And of those 20 cases, maybe 19 of them are small-time fender benders that settle for a few $1,000s each, barely covering the cost of the ads. But that 20th case, that one case might be a major commercial trucking accident, or a serious medical malpractice suit. A case that settles for $3 million. The lawyer's 40% cut is $1.2 million. Suddenly, that $50,000 ad buy doesn't just look smart. It looks like the most brilliant business decision imaginable. It's a form of high-stakes gambling where the house has a massive statistical advantage. You just have to play the game long enough to hit the jackpot. With that kind of money on the line, the ads had to work. The boring, lawyer in a library format wasn't going to cut it. It didn't stand out. This is when the archetypes we know and love, and sometimes mock, began to emerge from the primordial ooze of late-night television. The first and most powerful archetype was the fighter. This lawyer understood that when you're hurt and scared, you don't want a philosopher. You want a bulldog, a warrior. Their commercials featured deep, gravelly voiceovers, pounding gavels, and aggressive language. Insurance companies are bullies, they'd say, and we're here to punch back. They promised to fight for you, to go to war for you, to not rest until you got every single penny you deserved. They were selling strength. Then came the opposite, the gentle friend. This lawyer was all about empathy. Their commercials were shot in soft focus, often featuring the lawyer walking with their family or petting a golden retriever. The music was gentle, reassuring. They used their first name. "Hi, I'm Jim," they'd say with a warm smile. "At our firm, we treat you like family, because to us, you are family." They weren't selling a fight. They were selling comfort. They were selling the promise that someone would take care of everything while you just focused on getting better. And beneath it all was the most important development, the branding. The realization that in a moment of panic, the chaotic, adrenaline-fueled minutes after a car crash, a person isn't going to pull out the yellow pages. They're going to remember the name that's been drilled into their head 1,000 times. So the jingles were born. Simple, catchy, impossible to forget. And the phone numbers. Lawyers started buying up memorable, repeating digit phone numbers. 222-2222. 888-8888. It was a race to become the most easily recalled name in a moment of crisis. One call, that's all. Hurt in a car? Call William Starr. For the people. These weren't just ads anymore. They were cultural earworms, burrowing their way into the collective subconscious. The established legal community was watching this unfold in sheer horror. This was their worst nightmare realized. They saw the profession of John Adams and Abraham Lincoln being reduced to catchy jingles and guys in bad suits yelling at the camera. State bar associations, which still had the power to regulate advertising, tried to pump the brakes. They enacted a flurry of new rules. You can't use a paid actor as a client without a disclaimer. You can't promise a specific financial result. You can't use undignified or sensational material. But it was like trying to build a dam with sand. For every rule they created, the advertisers found a clever, and often hilarious loophole. Can't use a dramatization? Fine, the lawyer himself will reenact the accident with toy cars on his desk. Can't promise results? Fine, we'll just show a giant, fake check with the words "past settlement" written in the memo line. The backlash from the establishment didn't stop the advertisers. It just made them more creative, more aggressive. Sparked an arms race. If the lawyer on Channel 5 had a catchy jingle, the lawyer on Channel 7 needed a full-blown music video. If one firm branded themselves as a bulldog, another would brand themselves as a shark or a hammer or a hawk. The battle for the airwaves was on, and it was escalating fast. This was no longer just about informing the public of available legal services. It was about building local celebrity, creating brands, and constructing multi-million-dollar empires, one low-budget, high-impact television commercial at a time. The quiet dignity of the past was being replaced by a loud, brash, and undeniably American form of legal theater. And so the floodgates opened. But what poured through wasn't a diverse tapestry of legal specialties. It wasn't corporate lawyers in slick suits advertising mergers and acquisitions during the Super Bowl. No, what flooded the airwaves was something far more raw, far more personal. It was the birth of a new television genre. A genre built on a simple, powerful, and often devastating premise. You've been hurt, and someone needs to pay. This explosion was fueled by a specific, almost perfectly designed legal mechanism: the contingency fee. For centuries, the idea of hiring a lawyer was reserved for the wealthy. You paid a retainer, you paid by the hour, and the bills could be astronomical. If you were a factory worker who lost a hand in a faulty machine, or a secretary hit by a drunk driver, suing a massive corporation or a well-insured individual was a fantasy. You couldn't afford the first phone call, let alone a protracted court battle. The contingency fee changed everything. It was a key that unlocked the courthouse doors for the common person. The pitch was revolutionary in its simplicity. We don't get paid unless you get paid. Suddenly, the financial risk shifted entirely from the injured victim to the attorney. The law firm would front all the costs, the investigation, the expert witnesses, the court filings, the years of work, and if they lost, they ate the entire cost. But if they won, they would take a percentage of the settlement, typically around 30 to 40%. This single concept created an entirely new business model. For it to work, a law firm needed a constant flow of new cases. They needed volume. And what was the single most effective, most powerful tool for reaching a mass audience in the 1980s and 90s? Television. And so the formula was born. It was a formula honed not in a Madison Avenue advertising agency, but in the trenches of local TV stations. It was direct, unpolished, and brutally effective. First, the setup. The visual of a car wreck, twisted metal and shattered glass. An ambulance siren wailing in the background. An actor in a neck brace looking forlorn. The goal was immediate and visceral identification. The viewer had to see themselves or their worst fear on that screen. It was a direct injection of anxiety and empathy. Then came the lawyer. He wasn't a polished actor. He was often a bit stiff, staring directly into the camera lens, breaking the fourth wall. He wasn't in a fancy library filled with leather-bound books. He was in a practical, no-nonsense office, maybe with his sleeves rolled up. He wasn't selling a product. He was selling himself. He was selling trust, authority, and aggression. He was your protector. His voice was firm, maybe with a slight regional accent that made him feel like one of you. He didn't use complicated legal jargon. He spoke in the language of the working class. He used words like fight, justice, rights, and compensation. He wasn't offering to interpret the law. He was offering to go to war for you. And finally, the call to action, the most crucial part. A bold, simple phone number, often repeated multiple times. A memorable jingle or a powerful slogan that would burrow its way into your subconscious. Hurt in a car? Call William Matter. One call, that's all. The Texas Hammer. These weren't just marketing taglines. They were lifelines, mnemonics for a moment of crisis. The goal was that when the worst day of your life happened, when you were lying in a hospital bed, dazed and confused, that phone number, that name would be the first thing that popped into your head. This strategy was laser-focused on a specific demographic watching TV at a specific time. These ads didn't run during prime-time sitcoms. They ran during daytime soap operas, afternoon talk shows, and late-night movie reruns. They targeted shift workers, stay-at-home parents, the unemployed, the elderly, people who were more likely to be at home, and statistically more likely to be in a precarious financial position where a single accident could mean utter ruin. The ad wasn't just offering legal help. It was offering a potential financial rescue. It was a lottery ticket for the unlucky. This created a feedback loop of immense power and profitability. A firm might spend $1 million on television advertising. That $1 million generates 10,000 phone calls. Of those calls, maybe 1,000 are potential cases. Of those, the firm signs 100. They work those 100 cases, settling most of them out of court. And if just one of those cases results in a multimillion-dollar verdict for a catastrophic injury, the firm's 30 or 40% cut not only pays for the entire ad campaign but also funds the next one, and the one after that. It became a high-volume, data-driven business, and the TV commercial was the giant intake funnel at the top of the machine. Law firms that embraced this model transformed from small practices into massive, factory-like operations, sometimes referred to by critics as settlement mills. They were designed for efficiency and volume. Armies of paralegals and junior attorneys would handle the day-to-day grind of paperwork and negotiations, while the face of the firm, the man on the television, became a local celebrity, his face plastered on billboards, the sides of buses, and TV screens from dawn till dusk. This new breed of lawyer celebrity crafted powerful, mythic personas. There was the tough guy, the brawler who promised to punch back against the big insurance companies. He'd stand in front of an 18-wheeler, promising to take them on. He was the protector of the little guy, your personal heavyweight champion. Then there was the folksy patriarch, the calm, reassuring voice who spoke like your grandfather, promising to take care of everything with wisdom and compassion. He was selling peace of mind. And of course, there was the high-energy showman, whose rapid-fire delivery and unforgettable jingle made him impossible to ignore. He was selling confidence and speed. These weren't just lawyers anymore, they were brands. They understood that in the crowded marketplace of local television, you weren't selling legal expertise, everyone had that. You were selling a feeling of safety, a feeling of hope, a feeling that someone finally was on your side. Of course, the traditional legal establishment was horrified. They saw this as the degradation of a noble profession. They called it undignified, tacky, and most damningly, ambulance chasing. The term itself paints a ghoulish picture of lawyers literally chasing after ambulances to solicit wounded clients. The commercials, in their view, were just a high-tech version of the same thing. They argued that it encouraged a litigious society, convincing people they were victims who deserved a payout for every minor mishap. They claimed it clogged the courts with frivolous lawsuits and portrayed all lawyers as money-hungry sharks. But the advertisers had a powerful counter-argument, one that resonated deeply with the American spirit of fairness and access. They argued they weren't chasing ambulances, they were educating the public. How else was a regular person supposed to know their rights? How would they know that the first lowball offer from an insurance adjuster is almost never the final offer? How would they know that they were entitled to compensation for lost wages, medical bills, and pain and suffering? These commercials, they claimed, were a public service. They were leveling the playing field between powerful, sophisticated insurance corporations and the average citizen who was injured, scared, and vulnerable. They weren't creating victims, they were empowering them. It was a fundamental clash of philosophies. The old guard's vision of law as a dignified, quiet profession versus the new guard's vision of law as a democratic tool, accessible to all and advertised just like any other essential service. And in the court of public opinion, and on the airwaves of American television, the new guard was winning decisively. The age of the TV lawyer wasn't just dawning. It was taking over, changing the sound, the look, and the very business of justice in America. But as the competition grew fiercer, just being on TV was no longer enough. The game was about to get a whole lot more sophisticated. The first wave of lawyer ads was a novelty, a shock to the system. But novelty wears off. As TVs in the 80s and 90s became saturated with attorneys promising justice, a new problem emerged. How do you stand out when everyone is shouting? The answer wasn't to shout louder. It was to shout smarter. The era of the legal archetype was born, a period where law firms stopped selling legal services and started selling a personality, a brand, a feeling. And in doing so, they created characters as memorable as any on the sitcoms their ads were interrupting. First, you had the Hammer. This wasn't the friendly lawyer from down the street. This was a warrior. The Hammer's commercials were aggressive, filmed in stark, high-contrast lighting. He wasn't in a library surrounded by leather-bound books. He was on a construction site, in a factory, or just staring directly into the camera, his jaw set like granite. The message was primal and clear. The world is a dangerous place and you are a victim. You are weak, you are hurt, and the insurance company is a monster. But I am a bigger monster. I will take this sledgehammer, a literal sledgehammer in many ads, and I will smash the injustice, smash the bureaucracy, smash the greedy corporation that hurt you. This archetype wasn't about legal nuance. It was about channeling the client's rage and feeling of powerlessness into a singular, focused weapon. The Hammer promised not just compensation, but retribution. He was selling vengeance. On the complete opposite end of the spectrum was the gentle confessor. This lawyer's ads were shot in soft focus, often in a warm, inviting office that looked more like a therapist's room. Gentle, reassuring music would play in the background. Instead of staring down the camera, this attorney would be listening intently to an actor playing a client, patting their hand, offering a tissue. The message here was one of empathy. They understood your pain. They knew this was a difficult time for your family. Their kids played Little League too. They weren't a legal machine. They were a human being who would listen, who would care, who would guide you through this confusing process with a gentle hand. This archetype appealed to the profound vulnerability of an accident victim. While the Hammer sold righteous anger, the gentle confessor sold safety and understanding. They weren't a warrior, they were a guardian. Then came the local patriot. This lawyer wasn't about aggression or empathy. They were about trust and familiarity. Their commercials were a masterclass in community integration. You'd see them shaking hands at a local diner, wearing the town's high school football jacket, sponsoring the county fair. Their kids, their dog, their slightly too old station wagon. It was all part of the set dressing. The slogan wasn't about fighting or caring. It was about location. The Macon County lawyer for Macon County people. The implicit message was powerful. Those big city lawyers, they don't get us. They don't understand our lives, our values. I'm one of you. I shop at the same grocery store. I drive the same roads. You can trust me because I'm your neighbor. This was a brilliant strategy, creating an us versus them mentality and positioning the lawyer as the hometown champion, the only one who could truly be on your side. But as the money got bigger, so did the ambition. This gave rise to the corporate titan. This lawyer didn't operate out of a cozy office. They commanded a boardroom on the 50th floor, with a sweeping panoramic view of the city skyline behind them. They wore impeccably tailored suits and spoke not of injuries, but of complex tort litigation. Their commercials featured slick graphics, helicopter shots of their gleaming office building, and testimonials about 7- and 8-figure settlements. They didn't have a slogan, they had a track record. The message was one of overwhelming force and resources. The insurance company has an army of lawyers? So do we. They have unlimited funds? Look at this office. This archetype sold aspiration and intimidation. Hiring them was like bringing a modern financial battleship to a knife fight. They weren't just going to win your case. They were going to dominate the opposition on a scale you couldn't even comprehend. These archetypes were just the beginning of the sophistication. Underneath the branding, a ruthless science of direct response marketing was being perfected. The single most important innovation was the jingle and the phone number. The human brain is wired to remember melody and repetition far better than simple information. So law firms hired professional musicians to craft earworms, short, catchy tunes that would burrow into a viewer's subconscious. Hurt in a car? Call William Matter. One call, that's all. These weren't just jingles. They were mnemonic devices designed for a moment of panic. After a car crash, shocked and confused, you wouldn't remember the name of the firm you saw in the phone book. But that jingle, the one you've heard 1,000 times, would pop into your head, unbidden. And attached to that jingle was the Holy Grail, a memorable vanity phone number. In a world before smartphones and Google, the single biggest barrier between a TV ad and a new client was the difficulty of remembering and dialing a random 7-digit number. So firms paid fortunes for numbers like 444, 4444, 800, HURTNOW. The simpler the number, the lower the friction, the higher the call volume. It was a direct, measurable link between advertising dollars and client intake. The goal was to make calling a lawyer as easy and reflexive as ordering a pizza. The media buyers also got smarter. They realized they didn't need to advertise during prime time. Their target audience wasn't watching expensive dramas. They were home during the day. So they flooded the ad breaks of daytime television game shows, soap operas, and talk shows. The demographic was a perfect fit: people who might be out of work, potentially due to an injury, or those in lower-income brackets who were less likely to have a pre-existing relationship with a family lawyer. They bought up the cheap, remnant ad space in the late-night hours, catching shift workers and insomniacs, when lonely and anxious minds are more susceptible to a message of help and hope. They targeted Judge Judy and the People's Court, shows that primed the audience to think about lawsuits and legal disputes. Every ad placement was a calculated decision, aimed at a specific viewer at their moment of maximum potential need. But this escalating arms race of aggressive branding and scientific marketing created a deep rift within the legal profession itself. The old guard, the prestigious corporate law firms in their quiet, wood-paneled offices, were appalled. They saw this as a disgrace. To them, law was a noble and dignified profession, not a commodity to be hawked between commercials for laundry detergent and used cars. They accused the TV lawyers of unseemly solicitation, of cheapening the image of justice, and of preying on the unfortunate. State bar associations, often run by members of this old guard, began to push back. They tried to enact a dizzying array of new rules to curb the perceived excesses. Rules dictating the size of the font in the disclaimers. Rules prohibiting the use of actors portraying judges or happy clients if they weren't clearly labeled as actors. Rules banning sound effects like police sirens or crashing cars. It became a constant cat-and-mouse game, with advertising lawyers and their marketing agencies constantly probing the limits of the rules, finding loopholes, and pushing the boundaries of what was considered tasteful. The result wasn't a slowdown, but an acceleration. The backlash from the establishment only proved to the TV lawyers that they were onto something. It solidified their image as outsiders, as rebels fighting for the common person against a stuffy, out-of-touch system. The more the bar associations complained, the more clients seemed to respond. So the budgets grew, the production values increased, and the competition became a brutal zero-sum game played out on the airwaves. A law firm wasn't just a law firm anymore. It was a media company with a legal department. And at the head of these companies were the new celebrities of local television. The lawyer pitchmen, figures who were about to become more famous, more recognizable, and in some cases more bizarre than anyone could have ever imagined. And so the great television land rush began. But once the territory was claimed, a new war started. It wasn't enough to simply be on TV anymore. Suddenly, you were competing. In any given commercial break during the local news or a daytime talk show, a viewer might see 3, 4, even 5 different lawyer ads. How do you make your ad for Smith & Jones stand out from Jones & Smith? How do you make a viewer, dazed and confused after a car accident, remember your name and not the other guy's? The answer was simple, and it was an answer as old as marketing itself. You don't sell the service, you sell the story. You don't sell legal advice, you sell a hero. And from this crucible of competition, 3 dominant archetypes of the TV lawyer were forged. First, and perhaps most iconic, was the warrior. This wasn't just a lawyer. This was a fighter, a brawler, a gladiator who would step into the ring on your behalf. They didn't speak of torts and depositions. They spoke of battle and victory. And no one embodies the warrior better than a man from Kentucky named Daryl Isaacs. You might know him by his other name, the Hammer. His commercials are masterpieces of intimidation. He's not sitting in a dusty law library. He's standing in a sparse, industrial-looking space, sleeves rolled up, often holding an actual sledgehammer. The message is brutally, beautifully simple. The insurance companies are bullies, and I am the bigger bully who will beat them up for you. His commercials often feature testimonials from clients who talk about him like a savior, the one person who stood up for them when no one else would. The slogan, "One call, that's all," is a stroke of genius, implying effortless resolution to your chaotic problem. Just make the call, and the hammer will take care of the rest. This archetype appeals to a very primal human emotion, the desire for retribution. When you've been wronged, when you feel powerless against a faceless corporation, you don't want a negotiator. You want a champion. You want someone who will smash things on your behalf. And the Hammer and hundreds of imitators like him across the country, from the Texas Hammer to the Alabama Hammer, were more than happy to sell that fantasy of righteous vengeance. But not everyone wants a warrior. For some, the aftermath of an accident is a time of fear and confusion, not anger. They don't want a fighter. They want a protector. This gave rise to the second archetype, the guardian. This lawyer is the polar opposite of the hammer. They are calm, reassuring, and paternal. Their commercials are designed to feel safe. They're often filmed in a warm wood-paneled office, surrounded by books. The lawyer is usually wearing a soft-shouldered suit, maybe even a cardigan. They look directly into the camera, not with a warrior's intensity, but with a concerned, empathetic gaze. They speak slowly in a measured tone. They don't promise to smash the insurance company. They promise to take care of you, to guide you through the process, to handle the paperwork so you can focus on healing. Often, their own family members will appear in the commercials, reinforcing the image of a stable, trustworthy community figure. Their slogans aren't battle cries but promises of security. Let us be your voice. Or here for you, here for Houston. This approach is a masterclass in emotional intelligence. It recognizes that for many people, hiring a lawyer is an intimidating process. The guardian archetype turns that intimidation into an act of seeking comfort. They aren't a hired gun. They're a trusted advisor, the family friend you turn to when things go wrong. They are selling peace of mind, a promise that in your moment of crisis, a steady, capable hand will take the wheel. And then there's the third archetype, the one that truly pushed the boundaries of advertising professionalism, and some would say good taste. This is the showman, the gimmick king. As the airwaves became saturated with warriors and guardians, a new breed of lawyer realized that the only way to stand out was to be unforgettable, even if it meant being utterly absurd. They didn't want to just be remembered, they wanted to be burned into your brain. The undisputed godfather of this movement was a Louisiana lawyer named Lowell, the Legal Eagle Scott. In his legendary, low-budget commercials from the 1980s, Scott would appear on screen, often in a swamp or in front of a bad green screen, with a live bald eagle perched on his arm. The production quality was terrible, the acting was stiff, but it didn't matter. You couldn't look away. An eagle, on a lawyer's arm. He'd stare into the camera and declare, "I'm Lowell Scott, and I'll fight for you like an eagle." It was bizarre, it was cheesy, and it was marketing gold. Decades later, a new generation took this to its logical, explosive conclusion. Meet Brian Wilson, the Texas law hawk. His commercials are not ads. They are viral internet sketches. He rides jet skis, gets hit by cars, jumps through walls, and screams with the fury of 1,000 actual hawks, all while patriotic rock music shreds in the background. It is a sensory assault designed for the YouTube generation. The strategy of the showman is pure pattern interruption. In a block of boring commercials, they are a jolt of caffeine. They understand a fundamental truth of marketing. It doesn't matter how professional you look if no one remembers your name. The showman sacrifices traditional notions of legal dignity for something far more valuable in a crowded market: top-of-mind awareness. When you get in a wreck, you might not remember the guy in the nice suit, but you will absolutely remember the guy with the eagle on his arm or the maniac screaming on a jet ski. These three archetypes, the warrior, the guardian, and the showman, may seem wildly different, but they all operate from the same fundamental playbook. They all tap into the raw emotion of a personal injury, and they all follow a surprisingly rigid four-act structure. Act 1, the crisis. We see a jarring depiction of a car crash, a slip and fall, a workplace accident. This establishes the stakes and connects with the viewer's fears. Act 2, the villain. The screen fills with text about heartless insurance companies, medical bills, and lost wages. The viewer is made to feel helpless and victimized. Act 3, the hero's entrance. The lawyer appears. The hammer, the guardian, the showman. They deliver their core promise, their unique selling proposition, often punctuated by a catchy slogan. And finally, Act 4, the call to action. A massive phone number flashes on the screen, often a memorable vanity number like 1-800-HURTNOW, repeated over and over by an announcer. It's a simple, powerful formula that transforms a legal service into a dramatic narrative of crisis, villainy, and salvation. These lawyer pitchmen became local folk heroes. Their faces were on billboards, their jingles were on the radio, their catchphrases became part of the local lexicon. They weren't just lawyers. They were brands, local celebrities as recognizable as the star quarterback or the evening news anchor. They had successfully conquered the television landscape, creating a multi-billion-dollar industry from scratch in just a few short years. But this new golden age of legal advertising, with its sledgehammers, eagles, and explosions, was not without its critics. Inside the mahogany-paneled boardrooms of the old guard law firms and within the state bar associations, a different kind of storm was brewing. Many in the legal profession looked at these commercials with utter horror, seeing them not as clever marketing, but as a grotesque circus that was cheapening the very dignity of the law itself. They were about to fight back. And fight back they did. The reaction from the established legal community was swift and severe. State bar associations, the powerful bodies that govern lawyers in each state, were aghast. To them, the sight of a lawyer on a grainy television screen, sandwiched between a used car dealership and a jingle for a local pizzeria, was an abomination. It wasn't just about taste. They saw it as a fundamental threat to the very soul of their profession. Their argument, repeated in disciplinary hearings and sternly worded ethics opinions across the country, was centered on a single powerful concept: dignity. The law, they argued, was not a product to be hawked like a household cleaner. It was a noble calling, a pillar of society. Lawyers were officers of the court, a title that carried with it a sense of solemn duty and public trust. How could the public trust a lawyer who used the same cheap sales tactics as a man selling vinyl siding? They painted a grim picture of what this new world of advertising would create: a public perception of lawyers as money-grubbing ambulance chasers. They warned of an explosion in frivolous lawsuits, stirred up by attorneys trolling for clients on late-night TV. They feared it would create an unseemly race to the bottom, where the loudest, most obnoxious advertiser would win, not the most competent and ethical lawyer. And so, the bar associations began to systematically close the loophole that the Supreme Court had just blasted open. They couldn't issue a blanket ban anymore. Bates v. Arizona had settled that. But they could regulate. And regulate they did, with a vengeance. They began writing new, incredibly restrictive rules of professional conduct. The goal was simple: to make lawyer advertising so boring, so toothless, and so utterly devoid of persuasive power that no one would bother doing it. One state might ban the use of actors or celebrity voiceovers. Another would prohibit any jingles or background music. Testimonials from satisfied clients? Absolutely forbidden. Dramatizations of accidents? Unthinkable. Some rules were almost comically specific, dictating the exact font size and placement of disclaimers. Many states tried to limit television ads to a so-called tombstone format. Just the lawyer's name, address, phone number, and maybe a list of their practice areas, all presented in a static, monotone fashion. It was an attempt to legislate dignity back into the profession by strangling the life out of marketing. For a while it seemed like it might work. The pioneers of legal advertising found themselves navigating a minefield of arbitrary and ever-changing rules. A commercial that was perfectly legal in one state could get you disbarred in the one next door. But this crackdown created a new generation of legal rebels. These weren't just personal injury lawyers anymore. They were attorneys who saw these restrictions for what they were: an anti-competitive wall built by the old guard to protect their turf. They argued that these dignity rules were really about keeping the public in the dark and preventing smaller, newer firms from competing with the established white shoe firms that got their clients from country club connections, not television. This simmering conflict was about to boil over, and once again, it would take a single defiant lawyer to drag the entire profession back to the Supreme Court. This time the fight wasn't in Arizona. It was in Ohio, and the lawyer's name was Philip Zotterer. Zotterer was running a different kind of ad. It was targeted. In the early 1980s, a major lawsuit was unfolding against the manufacturer of the Dalkin Shield, an intrauterine birth control device that had caused devastating injuries to thousands of women. Many of these women had no idea that their health problems were linked to this specific device, or that they had any legal recourse. So Zotterer took out a newspaper ad. It was simple and direct. The headline read, "Did you use this IUD?" And right below it was a simple, hand-drawn illustration of the Dalkin Shield. The ad went on to explain the potential injuries and offered his legal services on a contingent fee basis, meaning clients wouldn't have to pay unless they won. The ad was a public service. It was also incredibly effective. Hundreds of injured women saw the ad and contacted his firm, finally getting the chance for justice they didn't even know they had. But the Office of Disciplinary Counsel of the Supreme Court of Ohio didn't see it that way. They saw a lawyer using an illustration to solicit clients for a specific case, and they brought the hammer down. They charged Zotterer with multiple violations of their ethical rules. They argued that using an illustration was undignified, and that targeting victims of a specific misfortune was the very definition of ambulance chasing. Zotterer refused to back down. He argued that the bar's rules were violating his First Amendment rights to free speech. What could possibly be wrong with providing truthful information to people who desperately needed it? How was a simple, accurate drawing of a defective product misleading? He argued that the bar's real motive was to prevent lawyers from effectively communicating with the public, thereby protecting the status quo. The case, Zotterer v. Office of Disciplinary Counsel, climbed the judicial ladder, and in 1985, 8 years after the Bates decision, the legal profession found itself once again standing before the 9 justices of the U.S. Supreme Court. The arguments were a replay of the same fundamental conflict. The Ohio State Bar argued for professional dignity and the need to protect a vulnerable public from what they saw as manipulative advertising. They claimed that allowing illustrations and targeted ads would open the door to a circus atmosphere, where lawyers would use increasingly emotional and dramatic tactics to frighten people into filing lawsuits. Zotterer's legal team fired back, framing it as a matter of public access to justice. Their argument was powerful in its simplicity. The First Amendment isn't just about the right to speak, it's about the public's right to receive information. Banning an accurate illustration doesn't protect the public, it keeps them ignorant. Banning ads about a specific legal problem, like the Dalkin Shield, doesn't prevent frivolous lawsuits. It prevents legitimate victims from ever finding a lawyer. They argued that as long as the information is truthful and not misleading, the state has no business telling lawyers how they can communicate. The Supreme Court agreed. In a landmark ruling, the court declared that states could not ban illustrations or other images in lawyer ads, as long as they were accurate and not misleading. They also affirmed that lawyers could, in fact, advertise for specific types of cases. The court's opinion was a stunning rebuke to the bar associations. Justice White, writing for the majority, pointed out the obvious. The illustration of the Dalkin Shield wasn't misleading. It was helpful. It provided information. He wrote that the undignified nature of an ad was far too vague and subjective a standard to justify suppressing constitutionally protected speech. The Zotterer decision was a seismic event. It was the crucial second punch that followed the Bates jab. Bates had said lawyers can advertise. Zotterer now said they can advertise effectively. It blew the doors open for creativity. It gave lawyers the green light to use visuals to be direct, to target specific audiences with specific problems. It essentially said that the old guard's definition of dignity could no longer be used as a weapon to stifle competition and keep consumers in the dark. This victory didn't just change the rules. It changed the entire mindset. The legal dam had been broken twice. First the right to speak, and now the right to speak in a language people could actually understand with pictures and direct appeals. The cautious black and white tombstone ads of the late 70s were now officially a thing of the past. The battle in the courtroom was over. Now a new battle was about to begin. A battle for market share, fought on the airwaves with million-dollar budgets. The era of the lawyer as a television personality, as a local celebrity, as a brand was about to be born. And things were about to get a whole lot weirder. And at first, the weirdness was subtle. It wasn't an explosion. It was more like a slow creeping leak. After the Supreme Court's decision, the majority of the legal profession remained horrified. For centuries, being a lawyer was about quiet dignity, about reputation earned through word of mouth in smoky country clubs and hushed boardrooms. Advertising was seen as something for used car salesmen and miracle vegetable choppers, not for learned members of the bar. It was considered tacky, unseemly, a betrayal of the profession's noble image. So for a year or two, most lawyers just didn't. They held the line, hoping this vulgar trend would pass. But a few brave, or perhaps just desperate, attorneys saw an opening. They were the outsiders, the ones who weren't getting referrals from the big banks or old money families. They were the ones trying to build a practice from scratch. And they realized that television, this glowing box in every American living room, was the great equalizer. It was a direct line to the people who actually needed their help. The factory worker with a back injury, the family hit by a drunk driver, the couple facing a messy divorce. And so, the first commercials began to appear. And they were glorious. Gloriously awkward. Imagine a man in an ill-fitting suit, standing stiffly in front of a fake library backdrop, blinking into the harsh studio lights. He's not a trained actor. He's a lawyer. And he's trying to recite a script he probably wrote himself, talking about wills and trusts with all the charisma of someone reading a grocery list. The sound quality is terrible. The camera work is shaky. It looks like it was filmed in a basement because it probably was. These weren't slick productions. They were raw, earnest, and deeply, deeply strange. But they worked. Because for the first time, a regular person could see a lawyer, hear their voice, and feel like maybe, just maybe, this was someone they could actually call. It demystified the entire profession. From this primordial soup of low-budget local ads, distinct species began to evolve. Archetypes that would define lawyer advertising for decades to come. First, you had the scholar. This was the guy in the library, surrounded by leather-bound books. He didn't shout. He spoke calmly, authoritatively. He'd break down complex legal concepts like no-fault insurance or Chapter 7 bankruptcy. His message wasn't "I'll fight for you." It was "I understand this so you don't have to." He was selling competence and wisdom. Then, at the opposite end of the spectrum, you had the birth of the brawler. The Texas hammer. The strong arm. The bulldog. This lawyer wasn't in a library. He was on a construction site, sleeves rolled up, or pointing aggressively at the camera. He didn't use legal jargon. He used power words. Fight. Justice. Win. Compensation. His ads were filled with crashing cars, shattering glass, and the sound of a judge's gavel hitting like a thunderclap. He wasn't selling knowledge. He was selling righteous fury. He was promising to be your personal wrecking ball, to go to war for you against the faceless, soulless insurance companies. This archetype was pure American machismo, bottled and broadcast at 2 in the afternoon. And of course you had the neighbor. This was the lawyer who presented himself not as a scholar or a fighter, but as a friend. He'd be sitting on a porch swing, or walking through a small town square, maybe with a golden retriever at his side. He'd speak with a gentle, reassuring tone. He'd talk about family, about community, about being there for you in your time of need. His slogan wasn't about winning. It was about helping. Just a local lawyer for local people. He was selling trust and empathy. As these archetypes took hold, the backlash from the legal establishment was swift and furious. Bar associations across the country were appalled. They decried this new wave of advertising as undignified, misleading, and a race to the bottom. They accused these TV lawyers of cheapening the profession, of turning the solemn pursuit of justice into a circus. The term ambulance chaser, once a fringe insult, became a mainstream condemnation. It painted a picture of ghoulish attorneys flocking to accident scenes, preying on the vulnerable. State bars tried to fight back. They passed a flurry of new hyper-specific rules trying to rein in the advertisers without directly violating the Supreme Court's ruling. You can advertise, but you can't use a jingle. You can state your fees, but you can't use a celebrity endorsement. You can't use actors. You can't show a dramatization of an accident. It was a game of legal whack-a-mole. For every rule a state bar created, an enterprising lawyer would find a loophole or file another lawsuit, claiming their First Amendment rights were being violated once again. The battle that started with Bates was far from over. It had just moved into the trenches of regulatory minutiae. But while the establishment was wringing its hands over ethics and dignity, the TV lawyers were doing something else. They were getting rich. Incredibly rich. And they were fundamentally changing the business of law. Before television, a law firm's growth was linear. You hired a new lawyer, you could take on a few more cases. But TV advertising introduced the concept of scale. Firms like Jacoby and Myers in California became the pioneers of this new model. They realized they could use television to generate a massive, constant flow of potential clients. They weren't looking for one big, multi-million-dollar corporate case. They were building a high-volume business. They wanted hundreds, even thousands of smaller personal injury, divorce, and bankruptcy cases. It was the legal equivalent of a factory assembly line. Get the client in the door with a TV ad, have a paralegal handle the paperwork, have a junior attorney manage the case, settle, and move on to the next one. This model required a huge initial investment. A 30-second spot during a daytime soap opera or a late-night movie could cost thousands of dollars. To run dozens of these spots every single day required a war chest. The small, one-man law offices couldn't compete. The firms that could afford to advertise grew exponentially, swallowing up market share. They opened multiple offices, becoming regional, and in some cases, national powerhouses. They weren't just law firms anymore, they were marketing machines that happened to practice law. And the core of that machine was the art of getting stuck in your head. The jingle, the slogan, the phone number. The marketers who now entered the scene understood a fundamental truth. When a person is in a moment of crisis, they've just been in a car wreck, they're in pain, they're confused, they're not going to pull out the yellow pages and do a comparative analysis of local attorneys. They're going to call the first name that pops into their head. And the goal of every lawyer commercial became to be that name. So we got the endlessly repeated, deceptively simple jingles that would burrow into your subconscious like an earworm. 444, 4444. Hurt in a car? Call William Matter. The slogans were even more potent. They were simple, memorable, and promised a benefit. One call, that's all. For the people. Tough, smart lawyers. These weren't just taglines. They were powerful psychological triggers. They created brand recognition on a massive scale. The lawyers themselves became local celebrities. People would see them in the grocery store. Their faces were on billboards, on the sides of buses, and on TV a dozen times a day. They had achieved a level of fame that the most respected corporate lawyer in the state could only dream of. The pioneers had proven the concept. They had weathered the scorn of their peers, fought the legal battles, and built multi-million-dollar empires on the back of 30-second commercials. They had turned legal services from a discreet, referral-based profession into a direct-to-consumer product, sold just like soap or soda. The weird, awkward, experimental phase was ending. The formula had been cracked. And now the real money, the professional marketers, and the data analysts were about to step in and refine that formula into a ruthlessly efficient billion-dollar industry. The gold rush was just getting started. The first wave of lawyer ads were like prospectors panning for gold with a tin plate. They were clumsy, they were loud, they were often ridiculous. But they proved one thing beyond a shadow of a doubt. There was gold in them, their hills. A lot of it. And once the professional mining companies saw that, they moved in with heavy machinery. The era of the amateur was over. The era of the marketing agency had begun. Suddenly, it wasn't just about getting a lawyer on camera. It was about optimizing every single second of that airtime for maximum psychological impact. It was about data, focus groups, and A/B testing slogans until they were honed to a razor's edge. This is where the madmen of personal injury law took over. They understood something fundamental. You're not selling legal services. You're selling a feeling. You're selling security. You're selling revenge. You're selling hope. And to sell a feeling, you need a formula. They started by analyzing the audience. Who is watching daytime television on a Tuesday? Who is up at 2 a.m., flipping through channels? It's often people who are homebound. Maybe they're retired. Maybe they're unemployed. Or maybe, just maybe, they're injured and can't work. Bingo! A captive audience in a vulnerable state of mind, watching programs sponsored by the very solution to their biggest problem. This targeting became a science. It's called day parting. You don't waste money advertising a $200 an hour corporate lawyer during Judge Judy. That's like trying to sell yachts in a desert. No, you run ads for personal injury and workers' comp. You run them during soap operas, daytime talk shows, and late-night reruns. You buy the cheapest ad slots, the ones the big national brands don't want, and you saturate them. You become part of the background noise of daily life for your target demographic. A constant, nagging reminder that if disaster strikes, there's a number to call. And that number became the holy grail. The marketers realized that in a moment of panic and pain, after a car crash, no one is going to remember a complicated law firm name. They won't remember Smith, Jones, Gonzalez, and Associates. The brain under duress craves simplicity. So, the race for the most memorable phone number and jingle began. This wasn't just about marketing, it was applied neuroscience. The human brain is hardwired to remember melodies and patterns. A catchy jingle bypasses the critical thinking part of your brain and lodges itself directly into your auditory cortex. It becomes an earworm. You can hate it, you can find it annoying, but you can't forget it. Think of the sheer, inescapable genius of the Cellino and Barnes jingle. 800-888-8888. It's not just a phone number. It's a rhythm. It's a percussive beat. It's so simple a child could remember it. And that was the point. They drilled that number into the collective consciousness of entire states. The jingle ran for years unchanged. That repetition is key. It's a psychological principle called the mere exposure effect. The more we're exposed to something, the more we tend to like it or at least trust it. You might not know a single thing about Cellino and Barnes as lawyers, but you felt like you knew them. Their jingle was the soundtrack to late-night television. It was as familiar as the theme song to your favorite show. And it wasn't just them. One call, that's all. It's not just a slogan. It's a promise of simplicity in a moment of overwhelming complexity. Hurt in a car? Call William Matter. It identifies the problem and provides the solution in a single, rhyming couplet. These weren't happy accidents. They were the result of endless testing. Ad agencies would create multiple versions of a commercial. One with a male voiceover, one with a female. One with a blue background, one with a gray. One with the slogan at the beginning, one with it at the end. They would run these different versions in small markets and track which one generated more calls. They would bring people into focus groups and watch their eye movements to see what parts of the screen they looked at. Every element was analyzed. The lawyer's suit couldn't be too flashy. It had to say successful but relatable. The books in the background had to be leather-bound to signal intelligence and tradition. The facial expression had to be the perfect blend of, "I'm concerned for your pain," and "I will fight ruthlessly on your behalf." This refinement process led them to the three emotional pillars that every successful lawyer commercial is built on: fear, anger, and hope. First, they stoke your fear. The ad paints a terrifying picture. The insurance company isn't your friend. They have a team of their own lawyers, and their only job is to pay you as little as possible. They'll twist your words, they'll deny your claim. They'll leave you with a mountain of medical debt, while their CEO flies a private jet. You are David, and they are a corporate Goliath. This fear is potent because it's real. People instinctively distrust large, faceless corporations. The ad simply confirms their worst suspicions. Once the fear is established, they pivot to anger. This is where the lawyer becomes a champion for the little guy. They tap into that deep American sense of fairness and justice. "You've been wronged," the ad says. "This wasn't your fault. Don't let them get away with it." The accident is no longer just a random, unfortunate event. It's an injustice. And that anger is a powerful motivator. It transforms the viewer from a passive victim into an active participant in a fight. The lawyer isn't just offering a service. They're offering to be your gladiator, to step into the arena and fight the beast on your behalf. And finally, after stoking your fear and channeling your anger, they sell you hope. And that hope almost always comes in the form of a dollar sign. They can't legally promise a specific result, but they can heavily imply it. They use phrases like maximum compensation, "Get the money you deserve," "We've recovered billions for our clients." They show images of happy families, people throwing away their neck braces, and checks with lots of zeros. This is the masterstroke. The ad isn't just about covering your medical bills. It's about hitting the jackpot. It's the idea that this terrible thing that happened to you could actually be a winning lottery ticket. It's the promise that a single phone call could solve not just your problems from the accident, but all your financial problems. Fear, anger, hope. It's a devastatingly effective emotional cocktail. And no one embodied the pinnacle of this formula better than the kings themselves, Cellino and Barnes. Their brand was a masterclass. Two guys, Ross Cellino and Stephen Barnes. They looked like lawyers from Central Casting. Their commercials were simple, direct, and hammered that unforgettable jingle into your skull. They built an empire that became a cultural phenomenon. And then the unthinkable happened. They broke up. And their very public, very messy, very bitter corporate divorce became the greatest advertisement they could have ever wished for. It was front-page news. It was a running joke on late-night talk shows. It was a Saturday Night Live sketch starring Bill Hader and Kenan Thompson. It became a torrent of internet memes. People were genuinely invested in the drama. Were you Team Cellino or Team Barnes? The breakup generated more free publicity and name recognition than millions in ad buys ever could. It cemented their status not just as lawyers, but as legitimate folk legends. It proved that the formula had become so powerful, so culturally pervasive, that the brand itself had transcended the commercials and become a piece of Americana. The marketing machine had not only cracked the code for getting clients, it had created icons. This was the new reality. Lawyer advertising wasn't just a niche industry anymore. It was a dominant force in media, capable of creating its own celebrities and its own gravity. And this perfectly polished, data-driven, psychologically manipulative machine was now ready to scale up to a level nobody thought possible. To understand what came next, you have to stop thinking about these law firms as, well, law firms, and start thinking of them as sophisticated, national-level corporations. Because the leap from a successful regional advertiser to a national behemoth wasn't a legal innovation. It was a business model revolution. This new machine scaled up by mastering 3 core principles that would be instantly recognizable to the founder of McDonald's or Starbucks: standardization, branding, and distribution. First, standardization. The old model was bespoke. A lawyer in one city ran their firm their way, with their own ads and their own process. The new model was a blueprint. These pioneering national firms created a replicable cookie-cutter system for everything. They developed a precise formula for the ads themselves: the exact phrasing, the tone of voice, the types of actors, the on-screen graphics. They perfected the script for the person answering the phone, turning a complex legal inquiry into a simple data entry checklist. They systemized the process of evaluating a case, assigning it a potential value, and routing it through their network. This blueprint could be picked up and dropped into any city in America. A car accident case in Miami would be processed in almost the exact same way as a slip and fall in Seattle. This wasn't just a law firm anymore. It was a product, and that product was the efficient conversion of an injury into a cash settlement. Second, branding. The goal was no longer to be the most trusted lawyer in Phoenix. The goal was to become the only lawyer anyone in the country could think of in a moment of crisis. This required a level of brand saturation previously reserved for soft drinks and fast food. It meant creating jingles so relentlessly catchy they became cultural artifacts. It meant designing logos and color schemes that were instantly recognizable from 100 yards away on a billboard. It meant hammering a single simple phone number, 1-800-ASK-SOMEBODY, into the collective consciousness through sheer brute force repetition. The brand became a promise, an abstract symbol of help that floated above any individual lawyer or office. You weren't calling a person, you were calling the hammer or the strong arm. This abstract brand identity was crucial, because it allowed them to solve the third and most important piece of the puzzle: distribution. And this is the real secret sauce. How does a law firm based in Houston represent a client in Portland, Maine, when the lawyers aren't even licensed to practice there? They don't. The national megafirm, the one you see on TV, often isn't your lawyer at all. They are a lead generation and marketing company. This is the linchpin of the entire model. When you call that national 1-800 number, you're not reaching a bustling law office filled with Ivy League attorneys. You're routed to a massive call center, potentially in a completely different state, staffed by intake specialists who are experts in one thing: getting your story and your signature on an electronic retainer agreement. Once you're signed, your case, your personal tragedy, becomes a commodity. It's a lead. That lead is then packaged and, in many cases, referred out to a local law firm in your area that has a contractual relationship with the national brand. That small local firm you've never heard of does all the actual legal work. They file the papers, they negotiate with the insurance company, they might even take your case to court. When the case is settled, the local firm takes their cut, and then they send a huge chunk of that fee, often a third or even more, back to the national marketing firm whose TV commercial got you to call in the first place. This is the genius of the model. The national firm bears the enormous cost and risk of the advertising. They spend hundreds of millions of dollars a year to make the phone ring. But they don't have the massive overhead of maintaining a fully staffed legal office in every single city. Instead, they've created a distributed network of local attorneys who are, in essence, paying them for pre-qualified signed clients. It's a franchise system for legal services. The national brand is the Golden Arches, and the local attorney is the franchisee flipping the burgers. This model created an economic feedback loop of terrifying power. A local firm could never afford to buy ad time during the Super Bowl. But a national firm collecting referral fees from thousands of cases across all 50 states absolutely could. And the more they spent, the more their brand grew. The more the brand grew, the more people called. The more people called, the more cases they could refer out. The more referrals they sent, the more money they made. And the more money they made, the more they could pour back into even more advertising. It created a moat around their business that was impossible for smaller competitors to cross. They weren't just outcompeting local lawyers anymore. They were making them obsolete or forcing them to join their network. They could buy media in bulk at discounted rates. They could leverage data from millions of calls to optimize their ad spend, knowing down to the dollar how much a lead from a daytime TV spot costs versus a late-night one. They knew that an ad aired during a Cops rerun would generate a different type of call than one aired during The Price is Right. This wasn't law. This was a sophisticated, high-volume, data-driven customer acquisition machine. The human element, the idea of a trusted local counselor, was systematically engineered out of the initial process. The face on the billboard wasn't necessarily the person who would handle your case. He was the chief marketing officer. The sympathetic voice in the commercial was a paid actor. The friendly person on the phone was a call center employee measured on their lead conversion rate. This national machine wasn't just changing television. It was fundamentally rewiring the business of justice in America. It was turning legal representation from a local service into a national product sold and distributed just like any other. But as these firms grew into billion-dollar empires, a darker side began to emerge. A side that questioned whether the client was still the priority, or just another number in a massive data-driven equation designed for maximum efficiency and profit.